Hi, I'm Jennifer Cona. Welcome to Cona's Corner. Elder law and estate planning are really complicated areas of the law, and we get questions from clients and people who talk to us out in the community about things that they hear and things that have happened to them. And we wanted to help answer some of those questions. And we also hear all kinds of nightmare kind of stories and things that we like to think about as don't let this happen to you. So we wanted to address some of those questions as we go forward and share those issues with you. So we're encouraging people to write in, whether they're clients or anybody out there in the public who has questions about things that they hear about or things that have happened, so that we can answer those questions. So we're going to start today with one question that someone wrote in recently, and I just wanted to share this with everybody and talk about what happened in this scenario. In this issue, the person writes in, "I'm concerned about paying my bills as I get older. Should I put my children on my bank account?" We get this question a lot. A lot of people want to do this. They want to add a child or children to their bank account because it sounds like an easy solution to allow your children access to pay bills, pay your mortgage, pay your utilities, what have you, just to allow access. So like I said, it seems like a really quick and easy way to solve a problem. But unfortunately, it creates a lot more problems than you may be solving. So let me just give you a quick story as to what happened to one of our clients. So one of our clients, unbeknownst to us, added her son to her bank account just for this purpose that we're discussing. She wanted him to be able to pay bills if she couldn't, things of that nature. Unfortunately, he lived way beyond his means. He charged all kinds of things all the time. He was just living high on the hog, way more than he could afford to. And as things kind of spun out of control, and of course his mom didn't know anything about this, but as things spun out of control, he eventually was not able to pay any of his debts back, and he was sued. He was sued by various creditors, and they were seizing his accounts. His name was on mom's account, and those accounts got frozen along with all of his other assets. That, of course, impacted mom. Now all of her assets got frozen because his name was on it. Anything that had his name on it was considered his to the creditors and was frozen. So now all of mom's money got locked up inadvertently, and that was clearly not what she intended to happen when adding her son to her accounts. It was the opposite effect. So this kind of stuff can happen, and it's certainly, an unintended consequence. So what should have happened in this case? Mom should have named her son as power of attorney, and that way he would have had access to her accounts if and when he needed it. So if mom needed help with bill paying or asset transfers or dealing with real estate transactions, her son could have stepped in at that time by using the power of attorney to help her out. And that would have been a far better solution, and none of those unintended consequences would have happened. So that is our advice. That would have been our advice to her. So it's those kind of simple things. There's no real simple answers when it comes to elder law and estate planning. So always reach out to us and we'll help you and we'll give you the best solutions. Have a great day, and feel free to write in with your questions to elder@conalaw.com. That's the email to write in with questions. We'd be happy to answer them. We'll do as many questions as we can each week. Thanks for tuning in, and we'll see you next time.